We'll take the next speaker, who is also going to treat a very important topic, which is protecting your private property in marriage. It's an interesting topic, isn't it? Well, to help us do this, please help me welcome our Justice of the Court of Appeal. He's no other than Your Lordship, Justice Alexander Osei Tutu. Let's give him a round of applause as the Justice comes to do us the honors. Welcome, sir.
Permit me, Madam Chair, to stand on the existing protocol and to speak on the topic, how do I protect my property in marriage? And I would want us to quickly consider this. When it comes to contracts, when people are entering into contracts, they get to know what is entailed, all the terms in the contract before they append their signature. But when it comes to contracting marriage, they just go and take the vows without knowing the consequences. But marriage is not only a spiritual thing for the Christians, it has legal ramifications. Properties that come out of the relationship will have to be shared. And you need to know how it works. But unfortunately, like I said earlier, last Sunday, people are blinded when they are marrying. They are blinded with the love and do not consider these implications. And the churches, even during their counseling session, only advise them towards the love and other things without seeking legal assistance to know the consequences of what they are entering into. So I ask myself, why is it that when we are getting married, we don't take the opportunity to get ourselves acquainted with the legal implications on the personal properties before we sign the marriage vows or contract? The previous speaker made us to understand the law that regulates property in marriage. And basically, we go to the Constitution, Article 22. And the Land Act of 2020, Act 1036, also has some provisions which touch on marital property. Some of these provisions are Section 38, Section 47, which provides that before one spouse can alienate a property, he or she needs the consent of the other spouse. Section 125, which provides that if a married couple is registering his land, the presumption is that it's for the two of them. So you go through all the processes. You must indicate whether you are married. And if you are married, before the certificate will be issued, it will be issued in your joint names. There are also judicial decisions which touch on joint ownership of property by the spouses. But we need also to, having explained that the law presumes joint ownership, there's another line of judicial decision which also suggests that an individual who is married can also own his or her private property. The Constitution, specifically Article 18, provides that every person has the right to own property. And the Supreme Court has given effect to this in Finn versus Finn, that even in marriage, the couples can own their personal or private property. And I believe recently, a J versus a J, where the Supreme Court held that if one of the couples applies for a loan to purchase a property until the loan is repaid, if the marriage is being dissolved before the repayment of the loan, that property cannot be deemed to be a matrimonial property. In other words, it's only when the applicant of the loan has been able to pay off the loan before that property can be considered. So you see, this line of authorities all support individual ownership of property, even in marriage. What at all do we mean by property? Property, basically, we are talking about movables, like this, my laptop, mobile phone, anything you can move from one place to another. We are also talking about immovable property, like landed property, houses, buildings, and all that. I also read about a lady in UK, it happened in UK, where a lady, during the courtship period, donated her kidney. And 4 years later, the man divorced her. 4 years later, after donating. That's why I said, when people are entering into marriage, they are blinded by the love. Without looking at anything can happen, the repercussions. And there are also instances where the man was living in a house, and when the parents died, he buried them. That the building has a family graveyard. And when the marriage was dissolved, the woman was to take everything. And what pained the man was not the property, but the woman having that family graveyard. So, how then do I clearly maintain the identity of my private property in marriage? The simple answer I'm advocating today is to enter into a prenuptial agreement. To enter into a prenuptial agreement. And when we talk about prenuptial agreement, we are talking about agreements between the would-be suitors or a couple to regulate their marriage. So before marriage, you enter into an agreement. You bring out all the properties or whatever you want to discuss. You put it down, and the two parties sign. I believe this woman who donated her kidney, if she had done that, I believe she would have had a better deal rather than being thrown out only after some few years into the marriage. The question is a prenuptial agreement lawful in Ghana? The previous speaker asked. Many lawyers think it is not lawful. But I'm here to tell you today that it's lawful. There is no law in Ghana which forbids prenuptial agreement. Originally, at common law, in England, it was not possible to dissolve your marriage. And before you could, or one could dissolve his or her marriage, he needed an act of parliament. An act of parliament to be able to dissolve marriage. But things have changed. And now, prenuptial agreement is recognized all over the place under virtually all the common law jurisdictions. Like I said, there's no law in Ghana which prohibits prenuptial agreement. Even under customary law, it was possible to dissolve one's marriage. Our law allows for the parties to agree on their own terms. If you read Article 22 of the Constitution, it provides that, it talks about property acquired during the substance of the marriage. You go to the Lands Act, the same thing. And Section 38, Section 47, if you read the law carefully, before the lawmaker even talks about what they are legislating on, they say, subject to agreement by the parties. So the parties themselves are permitted by law to agree on what. It is where there is no agreement before the law steps in. So somebody has why do you wait for the law to come and distribute your property when you can decide or choose a particular pattern the way you want it? But let's quickly look at some of the benefits which one gets if he enters into a prenuptial agreement. One, it makes it easier for properties acquired prior to the marriage to be identified. Before we enter into the marriage, you know that that land was purchased by the woman, or the man is bringing it. So we all know our assets, so that it will not happen that tomorrow, should there be a divorce, one of the parties will come and say, no, this property was acquired during the marriage. It's fair. The second reason is that it helps the parties to define liabilities. Where one party is coming with heavy debts, why should it be, why should one of the couple bring heavy debt for the other person to bear? At least we know, so that in the event of divorce, we know who brought what, and it makes things easier. The third is that it can help protect one's business and have it designated as a separate asset that will be immune in the event of divorce. Fourth, it may be used to protect a child. If, say, let's say the woman had a child from somewhere. From the onset, we know that, yes, I have a child. And these are the provisions we make for, or we are making for the child. It opens the parties to solid line of communications. Parties open up at the beginning of the marriage. So there is an element of trust that is able to hold the relationship together in turbulent times. From the onset, there was full disclosure. We are able to discuss everything. It makes divorce less complicated. This conabra, you spend many years in court fighting over properties and other things. Because from the onset, we made our own arrangement. You know that these are the properties which are for you. Those properties are for me. So it makes things quite easier for the parties than where they did not make any prior arrangement or prenuptial agreement. The next is when third parties have stakes in the assets or property. For example, property that belongs to one of the parties and his or her siblings. We know that the property is a family property. So at the end of the day, the other person will not expect to fight over the property. The next may serve as a guarantee for women. At the onset, what the man owns and plans for the woman are known before she commits herself to the marriage. Imagine a woman living with a man in his house, thinking that the house belongs to him, only for the man to die before discovering that their matrimonial home was a family property. So the woman would have been living in a, permit me, fool's paradise, thinking, oh, but if from the onset the man makes it known, the woman will not expect He will be assured. And the next is, it may ensure full disclosure and prevent disappointments in the marriage. A man pursuing a woman may say anything to cajole her, collect vehicles from friends to show off, only for the woman to enter the marriage to know that car did not belong to the man. At that stage, if the parties were Christians, it becomes too late for the woman to back out. Prenuptial agreement helps to prevent such occurrence. Why are some people against prenuptial agreement? One, they say it is a romance killer. There's no better way to kill the vibe of fresh lovers who are about to marry than bringing up the potential for a future divorce. It can also be used as a trap to control the partner who is entering into the marriage with less assets. The one with many assets may want to be in charge. Three, it may not seem attractive to some faith, believers of some faith, like Christians, who think what God has put together, let no man put asunder. Without consider, they may think that, why do we even enter into a relationship thinking that the marriage may fail? Or thinking that the marriage, the couple will divorce one day. It can be confusing in the minds of the people. In the view of some people, prenuptial agreement is planning for the divorce before planning for the wedding. You go for honeymoon and you'll be talking about prenuptial in the event of divorce. Practically, it's weird. Let's look at some tips to the already married. The prenuptial is for those who are about to enter, but they're already married. One, be mindful of the will you make for a spouse. Section 38 of the Matrimonial Causes Act provides that if you make a will for your spouse and there's divorce, the will is terminated or the provisions therein will lapse. What it means is that when you are making a will, think about, don't use certain words unless you want the property to go to the other person, irrespective of the consequence of the marriage. So in making a will, you need to have this in mind so that you know how to couch your words. You must also be mindful of the concept of advancement. For the non-lawyers, when we talk about advancement, it connotes, it's a common law principle which says that if a man purchases property in the name of his spouse, he cannot take it back. He cannot take it back. That's what we mean by advancement. So if, let me buy the property in your name, thinking that one day you can take it back. The law does not allow that. And the next is, we have already talked about customary marriage and the registration of customary marriage. Unfortunately, my colleague, Nana Kodia, is not here. I disagree with him on the point that the registration of customary marriage is not necessary because it is prima facie evidence, proof of the marriage. And when we say prima facie, with that document alone, you don't have to prove anything. The burden shifts to the other person to come and rebut it. But if we say we don't need it, there are matches we need to call, it will mean that we will now have to establish or prove it. We will now have to prove it. Why make things difficult for ourselves when with a document, the law says you are done? The burden now shifts. And in practice, there have been instances where, yes, a woman might have been married all right, but along the line, there's issue between her and the in-laws. The man passes, and they come to court to say, no, he never married her. But once you have it, it saves you. Simple. The last point I would want to make is, I'm taking you to the Bible. Luke chapter 14, verse 28. Jesus said something there. He said, if one of you is planning to build a tower, you sit down first and figure out what it costs to see if you have enough money to finish the job. This is what Jesus said. In other words, if you are planning to build a tower, building something is thinking about permanent, something that will be permanent. In the same vein, marriage is a lifelong relationship. You are expecting it to be hot, permanent. And so, before you enter it, why would you not consider the repercussions? Whether, this person, you don't just go and sign the marriage contract. Know the consequences. Jesus made this statement. So, from Jesus' statement, before one begins to build, he must first figure out how he would finish. If marriage is also entered into as a permanent relationship, it is then necessary to consider how it will end. Is it not better to step into the known than into the unknown? Thank you. God bless you.
Thank you, Justice Alexander Osei Tutu, for this wonderful presentation. I don't know, but I was just smiling all along, Justice. Do we often make such considerations when we're going into marriage? More often than not, we don't. So thanks for the insight and the reminders, Justice.